Hi, I'm Erin Collins, Associate Professor at the University of Richmond School of Law, and I'm here today to unpack for you the Supreme Court's recent decision in Terry v. United States. The case involves the claim of Mr. Terry, who's currently serving a 15-year prison sentence for possessing with intent to distribute approximately 4 grams of crack cocaine or cocaine base. Mr. Terry's argument is that he's entitled to a resentencing hearing under the 2018 First Step Act. To understand what's going on with his case, you need to understand a little bit about how Congress has historically treated offenses involving crack cocaine. It starts in 1986 with the now notorious AntiDrug Abuse Act. In that statute, Congress set up a very harsh punishment scheme for offenses involving crack cocaine. One who possessed with intent to distribute 50 grams or more of crack cocaine was subject to a mandatory 10-year prison sentence, which means the judge had no discretion to go below it. 5 grams or more triggered a 5-year mandatory prison sentence, and any amount, any unspecified amount, presumably less than 5 grams, would render one subject to a prison term from anywhere between no prison time, 0 years, to 20 years. Now, this sentencing scheme was subject to a lot of criticism, not only because the punishment is so harsh. Think about it, for example, a gram is approximately the weight of a paper clip. So one who possessed approximately 5 grams or 5 paper clips worth of crack cocaine got a mandatory 5-year prison sentence. But also because to get to these harsh penalties for powder cocaine, one had to possess with intent to distribute approximately 100 times the same amount. So instead of 5 paper clips, they would have to possess with an intent to distribute 500 paper clips worth of that substance. Congress has since taken some steps to address this disparity, and in 2010, in the Fair Sentencing Act, they reduced the ratio to 18-1, meaning that crack cocaine is now punished only 18 times as harshly as powder cocaine. And in 2018, Congress made this change retroactive, meaning that anyone, regardless of when they had been sentenced, could get the benefit of this reduced ratio. Which brings us back to Mr. Terry's case. Mr. Terry was sentenced in 2008. He argued essentially he was entitled to a new sentencing hearing. He got the opportunity, he said, to go before a judge and ask for a lower sentence. Unfortunately, the court found he was out of luck. They found he was out of luck because they said that the sentencing scheme essentially set up 3 different offenses. One involving the most severe amount, it's now 280 grams of cocaine base under the Fair Sentencing Act. The second one involving 28 grams or more of cocaine base. And the third one is now still unspecified, any amount of cocaine base, and it still carries the same 0 to 20-year penalty. The court reasoning that that third penalty had not been changed. It remains the same as it was when it was drafted in 1986. Therefore, the court reasoned neither the First Step Act nor the Fair Sentencing Act entitled Mr. Terry to any relief. Now, ironically, and as Justice Sotomayor points out in her concurring opinion, had Mr. Terry been convicted of an offense involving more crack cocaine, involving greater than now 28 grams, he would be entitled to relief. But because it was only 4 grams, he's out of luck and he is not entitled to a new sentencing hearing.